Blog Talk Radio.
Namaste, everybody. Welcome to Nature of Reality Radio. It is June 11th, 2014. I am your host, Andrew Fisher, broadcasting every Wednesday from 6 to 8 p.m. Eastern Standard Time to expose the true and false nature of reality for what it is and what it isn't. And today on the show, we are going to have Commerce and Admiralty law expert Winston Shrout, who will tell us all about how commerce and admiralty law affects us at both a physical and a metaphysical level. One thing I love about Winston, he's always willing to get metaphysical in his talks, unlike some other people who are law experts. He's not a lawyer, but he certainly could be one. Listen to a lot of his interviews. Very fascinating guy, and he makes studying law in your free time interesting. But first, we will begin with the news, courtesy of Alex Jones and company at InfoWars. First article, Democrats waste no time attacking David Brat. Libertarianism, especially when infused with Christianity, is violently rejected in Washington. Well, I must admit, I am not an expert on who this David Brat guy is, but I'm guessing he's a libertarian, considering the subtitle here. And, you know, the tyrannical government, since it wants Democrats and Republicans, or should I say Demo-Crips and Rebloodlicans, like Jesse Ventura would call them. Read his book, Demo-Crips and Rebloodlicans. It's a fascinating book by Jesse Ventura. And libertarian people who support private property and rights dearly and understand what law is are not appreciated by those in Washington, by the New World Order who controls the Democrats and Republicans in Washington, so shouldn't come as too much of an astonishment that they are attacking this David Brat guy. Next article. Fake conservatives terrified Cantor loss will embolden Rand Paul, Ted Cruz. Rand Paul supporters are going to use this as an excuse to basically stop the government from functioning. This whole thing about the Cantor loss, I have seen a little bit about this, and anytime a tyrant gets kicked out of government, then you know that supporters of people who support liberty like Rand Paul and Ted Cruz, they're going to get happy because this is a huge blow to the New World Order, I guess. And, some people say that Rand Paul and Ted Cruz, they're obviously the two most benevolent politicians in government right now in terms of caring about the people. But, hey, even they have a few problems when it comes to trying to protect people's rights by getting the government a little too much involved in our lives. I mean, people might say, well, that's okay. If the government gets involved in our lives for the sake of protecting our rights, that's perfectly fine. But I don't know. Some people say that might cause a slippery slope. And though Rand Paul and Ted Cruz may be the most benevolent of them all, they are they do have a few problems when it comes to letting the government get involved to support people's rights. And hey, I'm still going to support them, but if they ever do something like that, let the government get involved a little too much for the sake of supporting people's rights, I might say, hey, don't take advantage of this. We know you care about us, but we don't want you to become a tyrant. Hey, Rand Paul, Ted Cruz, I love you. Please don't take what I said out of context. Okay, next article. This is red link, by the way. Obama endorses Australian-style gun confiscation. President ignores drop-in gun crime, applauds Australian gun confiscation. Yeah, that shooting in Tasmania that the Australian government used to justify disarming the Australian people. So obviously a false flag staged by New World Order forces. Emphasis on New World Order forces, not Australian government forces, because the Australian government, like all national governments on planet Earth, are bought, paid for, and controlled by the New World Order, and they want to disarm the population so they can inflict tyranny upon the population. Let me just say something here to Winston on Skype. All right, next article. Tea Party candidate topples House Majority Leader Eric Cantor. Yeah, he was the House Majority Leader, that's right. I should have known that if, I don't know, maybe I'm just dreadful with names for some reason. I'm able to memorize a lot, but when it comes to names, I seem to have a little bit of a problem. I wonder why. So, Tea Party candidate, yeah, the Tea Party formed by Ron Paul, not Rand Paul, Ron Paul. Ron Paul was definitely benevolent in every single way. Wouldn't even get the government involved too much in ways to protect the rights of the people. He knew, okay, I want to protect the rights, but I don't want to get the government too much involved, so I won't do that. I mean, that's what we need Ted Cruz and Rand Paul to do as well, and of course every other politician in government for that matter. But this, I guess, is a big blow, like I said. So next article, Iraq would not have an al-Qaeda problem if the state allowed citizens to be armed. The state cannot protect individuals from al-Qaeda or any other violent threat. Yes, let's arm the population so they can protect themselves from gang violence and tyrannical government. No, the tyrants of the government don't want that. So they want to inflict tyranny, so they're going to disarm us. Hang on, I'm just going to quickly make a thing here with Skype. All right, next article here. White House, Obama prepared to act unilaterally again using executive authority on guns. President Barack Obama is looking for new ways to act administratively unilaterally using his executive authority to enact a new gun control legislation. Yet, going back to what Australian-style gun confiscation is what Obama wants to do. The president, who is not supposed to be a dictator, as Obama is acting, worst president ever in terms of acting like a dictator, Obama is. The president is supposed to be the quarterback. He's supposed to, so to speak, the quarterback of the government. Congress is the whole entire team. The Supreme Court is part of the team too, and the president is just the quarterback who, at the end, has the authority to veto a bill passed by Congress at the last minute if he disagrees with it, a bill. But Congress does have the authority to override that, by the way, so that makes sure the president is not a dictator. But Obama, he's just signing executive orders, which, by the way, the only executive orders that are legal are the ones that only apply to the executive branch of government. Any one that applies outside is null and void. Executive orders outside the executive branch are null and void. No questions asked, but Obama doesn't seem to understand that. President also is supposed to be the commander-in-chief of the military. If there's a war going on, he's supposed to be the quarterback of the military, saying this way, that way, this is how we're going to be fighting, this is the way you're supposed to go and everything. And Congress is supposed to have some say in that too, but the president is commander-in-chief. He's the quarterback of the military, but Obama is acting like the dictator of the military. All right, one more message here for Winston. All right, so he's going to call in shortly, but two more articles here, actually. Illegal immigrants intentionally surrendering to Border Patrol to gain entry to U.S. Illegal immigrants are reportedly signaling federal officials to detain them once they are near the U.S.-Mexico border. Yes, the U.S. government is going to try to get illegals into this country. The Border Patrol is a total scam. It's supposed to let illegal immigrants into the country. That's what they're doing secretly, even though they don't want us to know that that's what we're doing. The whole idea is to let illegal immigrants work for pennies on the dollar for jobs in this country, to keep us all out of jobs, shut us all down, and then they can either depopulate us or microchip us after all our jobs are taken by illegal immigrants. And my God, this is disgusting that they would let illegal immigrants get into this country to shut down the economy. And by the way, speaking of the economy shutting down, July 1st, new bill is being passed that's supposed to say that countries who use the dollar as their world reserve currency have to report to the IRS, and many countries will not want to do that, so they will abandon the dollar. Well, that's worst case scenario, which might cause the dollar to go dead. So I just bought $2,000 worth of storable food for the price of $1,000. It was a price I couldn't pass up. I don't think the bargain's available anymore, but I hope you guys might prepare. Don't assume the Andromedans are going to come and let us all ascend into higher fourth dimensional consciousness. No, you can't think like that. You have to be prepared in this matrix for a catastrophic timeline if it happens, even though many people are saying there is going to be no catastrophic timeline. It's best not to think like that, I believe, because, hey, the human race, they are just so, I know this is going to offend some people, but like Jordan Maxwell said, they're too paradigmatic, too wishful thinking, and too stupid. Jordan Maxwell says stupid. The human race is to a great extent that he doesn't think there's going to be anything other than a train wreck coming where the New World Order takes over. I mean, I have seen evidence that he's wrong. George Kavazos, among other people, said Earth is love-based at its heart, soul essence, so the New World Order can't take over, but still. Storable food, it's a bargain anyway, because it lasts 25 years. Even if I don't need it now, I'll have it in the future, even if the economy doesn't collapse. But anyway, one more article here. Russia is doing it. Russia is actually abandoning the dollar. Oh, what did I just say? The Russians are actually making a move against the petrodollar. I can certainly understand why the dollar will lose value, whatnot. He says he has to call. Please call. He's going to be calling in any second now. I just told him to call 6464. Oh, by the way, this is the call-in number. I'm not going to be taking calls until at the very earliest, an hour and 15 minutes into the show. That'll be 7:15 Eastern. The call-in number, if anybody wants to call in, is 646-478-4747. That's if you have a question for Winston, or maybe you have a question for me. I'm sure we'll answer it. Try to keep it on the subject of commerce and admiralty law. Don't be afraid of getting metaphysical. Winston likes to get metaphysical. That's one thing I like about him. That's why he's a great candidate for this show. So all I have to do is wait. Might as well get a drink of water while I'm waiting here. They'll call in any second now. Hopefully I don't have a problem in which they can't call in using Skype, because Lennon Honor I had a problem with that earlier when I tried to click call into the show. The launch application thing didn't pop up for some reason. I don't know. It might be a little glitch with Skype for some reason. I had a lot of glitches with Direct Connect. But okay, this is probably him right here. Area code 503. Is this Winston Shrout?
It is.
How are you doing, man? Very glad to have you on. I remember maybe 6 months ago, wanted to get you on, but you were too busy throughout the winter. So now I finally get to have you on. And in many ways, your work is where the rubber meets the road. And in many ways, your work is where the physical and the metaphysical combine, because I've already said it several times. I'll say it again. I know you like to get metaphysical in your talks. I've heard some of your talks like that. But we're going to be talking about commerce and admiralty law today. But first, why don't you introduce yourself and tell people where they can find you?
Well, my given name is Winston Shrout. I've been lecturing under the title of Solutions in Commerce for about almost 10 years now. And you can go to the website, which is www.wssic.com, which stands for Winston Shrout Solutions in Commerce. And I also have a sister website, which is kind of on the metaphysical side, which is www.exocommerce, that would be exocommerce.net. And you can visit those websites on the WSSIC website. We have a YouTube section. You can listen free to many of the interviews I've previously done and so forth. I suppose this interview will be posted there as well. And then you can look at the various things that we have to offer as far as products and so forth and so on. And then on the exocommerce.net website, I've actually just gotten that started. We have some YouTube presentations on that, also some articles to read and so forth and so on. So anyway, that's where I can be found.
Okay, and I'd like to give you the floor, and I'll tell you what I want to give you the floor about. Jordan Maxwell once said, there are two types of law in the world, Roman civil law and maritime admiralty law. Your work focuses on the latter. Some people don't use the phrase maritime admiralty law, they say maritime commercial law, but since the courts are in an admiralty setting, they can substitute the word admiralty, the word commercial with admiralty. And anybody who's watched Dean Clifford's presentations would know that trust law is also utilized in the courtroom, but even at some level, a trust is a commercial transaction. Therefore, maritime commercial admiralty law trust law is a form of maritime admiralty commercial law. Now, I'm interested in knowing how maritime admiralty law works, and I'm also interested in the history about it. I say give you the floor, but I guess 30 minutes. I'd like to try to keep it to 30 minutes because I do have other questions to ask you, but you've got the floor for 30 minutes. Tell us, what is maritime admiralty law, how does it work, and give us a little history about it too.
Sure. Perhaps the first thing to look at would be the history of how it all came about. In many instances, I like to trace the history back basically to the Garden of Eden story, but I won't go there this time. In our more recent history, I should say, as the Europeans in particular set out to discover the world, to look at things over, they set out upon the salt water. Now, salt water certainly is different than fresh water. Fresh water you can drink. Salt water is poisonous to the human system. And so in any event, as they went out to explore the world, the planet, and so forth, they set out upon the salt water, and they had to have some form of a regulation and so forth, so they could settle any kind of disputes that might come up and so forth. And so on that basis, then, the courts of the Admiralty were created to deal with anything that involved itself with trafficking upon the salt water. Now, the Admiralty courts themselves sat upon the land. So the disputes and so forth that might need to be settled that occurred on the salt water were actually brought upon the land so they could carry on their business. I would suppose they could have had ships, that dealt with Admiralty cases on the high seas, but they did not. The courts actually sat upon the land, which created basically a conflict of interest in some respects. Now, as history went on, and as competition in the court systems developed, I'm sure that the Admiralty courts looked around at all the various things that were available in regards to a money-making opportunity and realized if they could take jurisdiction from some of the other court systems, simply they would have more business. So more business, more money, more control. And so eventually things were arranged in such a way that gradually the Admiralty jurisdiction basically moved up the waterways, up the fresh water, rivers, tributaries, and so forth. And then they started to spread across the land, started to make excuses or to redefine the jurisdiction and so forth, so that they could adequately compete with, for instance, the common law courts. And so then it got to be a dispute of who had the jurisdiction over this situation or that situation. And then to further move in that direction, maybe I should explain the difference between commerce and trade. Basically, the word commerce historically referred to the king's business. In other words, whatever the king was doing, that was called commerce. Now, we had the middle class, which was comprised basically of merchants, and merchants operated on a different law system altogether. They operated from the position of what was known as merchant law, which was a system of law that was developed over centuries to accommodate the merchants in their business, and they had their own courts. But in any event, commerce referred to what the king was doing, and then the word trade applied to the business that was carried on by the merchants, and so that was called maritime. So the king's business was under the Admiralty historically, and the maritime was under trade with the merchants historically. Now, an interesting thing happened, and that was when the merchants started to use the king's money or the king's currency in their business, then they fell under the jurisdiction of the Admiralty. In consequence of that, commerce and trade melded together, and hence Admiralty and maritime jurisdictions melded together, And so the upper hand at that point, in most instances, was held by the Admiralty. And so that's how things kind of got into the shape, as we have it today, because in today's world, our jurisdiction has been developed just basically or almost exclusively under the Admiralty jurisdiction. Now, as for a further explanation of how this came about, there's one important concept that has to be looked at that will give a good explanation of how this came about, and it has to do with the concept of bankruptcy. Bankruptcy is a function that we find under the Admiralty. And so the bankruptcy situation is dealt with in the Admiralty Court. Now, to further facilitate that, especially as we come down to our day and age, we go back to the period around 1933, where it was determined for various reasons, and I can't go into all the history of that, but it was determined that for instance, the United States would go into a different form of bankruptcy than they have previously been. A lot of people do not.
Hey, Winston has dropped offline. I'm going to let him know he called in. You dropped off. Hopefully he'll be back in a second. I hope you're finding the history here interesting. Some people say learning history is boring, and some people would say learning history is wrong because a lot of history is misguided in a sense. But no, Winston understands what he's talking about here, even though, as David Wilcock might say, he sounds like a lunatic. Some people might think he knows what he's talking about here. And well, it says he's still online here, but he called out of the show for some reason. So even though he's online, and hopefully he'll call in any second. But I got some other subjects to talk about here. When he's finished talking, I guess I'll extend give an additional 5 minutes since this happened. So he's talking about bankruptcy. Yeah, our country is. Here he is again. Hopefully this. Hey,
Hello.
Winston, you're back on the air. Was that just some strange technical issue there?
Yeah, some reason it dropped off. Anyway,
right.
I was. Go ahead.
Keep going. Keep talking.
Okay. Well, I have been going into the concept of bankruptcy, and perhaps I should go back historically and develop the concept. A lot of people don't realize it, but the United States of America has always been in a bankruptcy situation. We go back to the Articles of Confederation. If you look closely at the history and what it says in the Articles of Confederation, the Articles assumed the debt of the colonies. And so the Articles of Confederation created an aggregate corporation which was bankrupt, and so a corporate entity was put forward to carry that debt. And so the debt of the colonies was assigned to the United States of America, and that the Articles of Confederation was actually the first declaration of the bankruptcy. Now, a little later on, because it was felt like perhaps that the Articles, did not successfully address all of the issues that were needed to be looked at, a second proposal, a second draft, or a second document was created, which was known as the Constitution for the United States of America. And that organization, that corporation, assumed the liability that was under the Articles of Confederation. Now, national bankruptcy is for a period of 70 years. And if you go from the date of the Constitution, add 70 to it, which was the first period of bankruptcy, we come down to 1859. At that point, the decision had to be made either to liquidate and turn over the United States of America to the creditors, which was in fact the Bank of England, East India Trading Company, the Crown of England, King, all those kind of things. So the decision had to be made whether to liquidate the United States and turn it over to the creditors at that point, or to enter into a new period of bankruptcy, again, for another 70 years. Certainly the Europeans during that period of time had anticipated dividing up among the creditors the United States of America. I mean, the French, the British, the Spanish, they all had interest here. And so anyway, as a result of some of those expediencies, there was a war entered into to solidify the position of the federal government. And in essence, what was entered into was a second period of 70 years of bankruptcy. Now, that 70 years ended in 1929. Now, there's a lot of other elements that are going on during this period of time, and certainly internationally in 1928, there had been promulgated what was known as the Plan of the Experts, which called for certain things. One of the things that they called for was a consolidation of all gold bullion. And so those things were implemented and being worked on at that time. But in any event, the second period of national bankruptcy, which ended in 1929, the debt certainly had not been resolved at that point, and in consequence of that, it was anticipated that a third period of bankruptcy would be undertaken. Now, this third period of bankruptcy is very significant in that slavery was introduced. Now, I use that word in its strictest sense. I'm not talking about what happened to the African people, the Irish, the Chinese, and so forth, who were involved in involuntary servitude. But the term slavery basically is an Old Testament term. What it refers to, if a debtor cannot pay a creditor, then they can go into slavery and work off the debt. And this is exactly what happened in this third period of national bankruptcy, in as much as through various devices, the property, the labor, the products of the labor of the people were pledged to the creditors. And so as a result of the slavery that existed starting in 1929, which continued for another 70 years, as a result of that slavery, then in 1999, the people of the United States of America emerged debt-free. And I think Bill Clinton even said it. At one point, I recall hearing him say that he was the last United States president. And he was correct in that, because after 210 years of bankruptcy, then the country, the people, the nation, and so forth emerged out from under the bankruptcy, and at that point were free of the creditors, and at that point could determine their own destiny. Now, certainly since 1999, the country, and then I'll bring this back in a moment, but the country has been operating as a corporation, basically the United States Incorporated, which is a maritime corporation headquartered in Puerto Rico. In any event, the United States Incorporated basically has been running the country, as it were, and I think we all see how that's worked out, not too well. But in any event, we have to consider all this bankruptcy. Now, as mentioned, we did have what was called a civil war, which was a war of consolidation by the federal government. It was not a war between the states. It was a war against the states by the federal government. And as it turned out, as history shows, the federal government won that war. In consequence of that, all of the states have been under military occupation ever since then. Now, the corporation that existed, that we call the federal government, was centered in Washington, D.C., and they did a certain amount of consolidation during that period. I think the significant dates on that, if some want to go and study, that would be 1871, 1878.
I don't know why Winston is getting kicked off again, but hopefully this won't be a trend. He is going to call in. I know he will. Yeah, that's a good way of looking at the Civil War. It was not a war between the states. It was a war against the states to consolidate everything, all part of the New World Order's plot to bankrupt, like they want to bankrupt now, but to consolidate everything, to join everything together. So, because it's easier to rule if they're all, if everything's consolidated into one, so you don't have to worry about individual parts. So whose fault is this? Winston's Skype system or just Blog Talk Radio having some sort of a glitch? I do hope we don't have to keep continuing with this. I'm sure it's not the NSA pressing a button because they don't want him talking about this stuff. That would be kind of ridiculous now, wouldn't it, to think that that's what's actually happening. But here he is again.
Well, I switched over to a different phone system. Maybe this will work better. I don't know what the problem is on your end or mine, but maybe this will
I don't know
work
either.
better.
Hopefully this won't keep continuing, but hey, keep talking. You got the floor for another, I'll give you 20 minutes because of all this glitch problem if you need it.
Well, I was just getting to the point to explain that the federal corporation, which was centered or is centered in Washington, D.C., went through a certain amount of evolution themselves. And it was obvious, certainly by 1903, that the federal government could not meet the burden of debt that they were carrying. And so certain things were anticipated, European interests and so forth were involved. I think everybody's familiar with the creature from Jekyll Island and all that kind of history and so forth. But in any event, by 1913 was when the Federal Reserve Act was actually written. And it was put in place. A lot of people say it was illegal, so forth and so on. But in any event, if you go to international law, if something is introduced and is not objected to by the people of the country under what's called the law of proscription, it goes into effect in law. So in 1933, the Federal Reserve Act, became law. Now, is that good or bad? It depends on your point of view. I mean, a lot of people jump up and down and tear their hair out over it and whatnot. And I can't say whether it's good or bad. It just is. And if that's what we have, then certainly it would be imperative to learn how to deal with it. Now, in 1933, we had certain enactments, which transpired. Part of it was due to the plan of the experts, which was a proposal or a plan put forward for international commerce and so forth. In any event, the gold and silver, well, actually only gold at that point. Silver went out right after the Civil War, technically. But in any event, in 1933, gold was taken out of circulation as a usable currency for money in our system, and in consequence of that, there was a remedy put in place. Otherwise, the leaders who instigated the removal of gold from currency would have been guilty of treason. And so a remedy was put forward, and the remedy that was brought forward is known as discharge of debt. Now, the discharge of debt is an interesting word. The word discharge itself is an interesting word. Discharge does not extinguish the debt. It simply puts it off into the future. And so it's more in the line of an avoidance of settlement. And so the remedy that was put forward to the United States citizens as under the 14th Amendment was the discharge of debt. And I think for those who might want to do some study on that, I'll refer them to House Joint Resolution 192 of June the 5th, 1933. A study of that will be very interesting in as much as it will show you, or it will indicate to you certain things, and you have to read that House Joint Resolution with a certain amount of let's say. Sometimes you have to look at things kind of from a left-handed point of view to understand what's actually being said. But in any event, for those who have studied, they're very familiar with this particular thing, which was later codified into the statutes, into the United States Code and so forth. But one of the key points there that was brought up was that you cannot pay a debt with a debt. Cannot pay a debt with a debt. And so, in essence, what happened then in 1933, because it became impossible to pay a debt, the only remedy for a debt was discharge. That was the end of the common law, because in the common law, you have to pay a debt. And then with these enactments that came around in 1933, it became impossible to pay a debt. And then as you go on a little bit further in history, certainly after World War II or during World War II, people are familiar with the Trading with the Enemy Act, which after World War II evolved into a situation where the people became enemies of the state. And then at that point, it became unlawful to pay a debt. So the only remedy that was available during those times was the remedy of discharge. Now, discharge of debt, again, it plays itself right back into the concept of bankruptcy. And the bankruptcy came from, or the jurisdiction for the bankruptcy is the Admiralty jurisdiction. So from a historical point of view, I know I've given a lot of history here that needs to be thought about and so forth, but I was given this whole history here to indicate why it is that we have involved ourselves with the Admiralty jurisdiction. And so, for all intents and purposes, I would have to guess that, perhaps, 99% of all court cases, either civil or criminal, simply involve themselves in the Admiralty jurisdiction under the bankruptcy. Now, I'm not really sure when it started. Maybe Representative Trafficante, could give us some light knowledge on this. Of course, he got it in front of the House and exposed it on the public record, whereas he exposed that the United States was involved in a Chapter 11 reorganization bankruptcy. Now, a Chapter 11 is an interesting animal. I think people are mainly familiar with Chapter 7 liquidation-style bankruptcy, but a Chapter 11 is considerably different inasmuch as it is a reorganizational bankruptcy for a corporation. And so it's obvious if the United States has been involved in the Chapter 11 that they're a corporation. So, to dispel all myths in that regard, it's obvious. It's obvious that the United States, whatever you want to call it, is in fact a corporation because they're operating a Chapter 11 bankruptcy. Now, in the Chapter 11, we have a different circumstance than most people would think, inasmuch as the party who files the Chapter 11 is known as the debtor in possession. Now, the debtor in possession fills the function that would normally be filled by the trustee. Now, for those who are familiar, with bankruptcy generally, you understand that the purpose of the trustee is to represent the interest of the creditor or the creditors. So when the United States went into this Chapter 11 as debtor in possession, they fill the function of a bankruptcy as the trustee, and the trustee has the responsibility to protect the interest of the creditors. Now, who are the creditors of the United States? Of course, it's the people. So now all of a sudden we have the government, or the federal government, which is debtor in possession in the Chapter 11, allegedly taking on the position as trustee for the creditors. Now, that's not such a bad problem. It's not such a bad problem at all, with the exception that because of the adversarial nature of most people, they seem to want to argue about stuff and fight over stuff. And so when the federal government comes with a request for something, money or labor or whatever, people seem to want to fight about it. Now, when they resist that, then they get into the position of a delinquent creditor. And from the position of delinquent creditor, then they are forced into a Chapter 7 liquidation. So that's why people end up paying traffic tickets, court judgments, going to jail, et cetera, because, in fact, they go into the position of delinquent creditor. And certainly, all provisions of due process of law go out the window because of the Trading with the Enemy Act, whereas all the citizens are considered enemies of the state and hence enemy combatants. And so people get into these things, and start to argue from the incorrect position. And so all these travesties, as we look at them, that we have to suffer with, as we suppose, are basically due to our lack of knowledge, our ignorance of the circumstances as they truly are, are there remedies for these things? And the answer is yes, and that's what I've been lecturing on for the last 10 years, is to point people to the remedies and how to operate successfully within the Admiralty jurisdiction. Okay, well, that's kind of a long spiel there, Andrew.
Well, that was very informative. I enjoyed it, except for the two glitches there, but we're just going to forget those happened and move on. I do have some important things I want to talk about. First of all, in regards to what you said about the United States being a corporation, people don't seem to understand the illusion that the term United States with a capital letter U and a capital letter S refers to the United States Corporation, which masquerades as the American government. On the other hand, the term United States of America with a lowercase u in United, that four-word term United States of America refers to the consortium of 50 states that make up the country, and the country is called America. I just wanted to clear that up for all the people that don't seem to understand that fact. But one thing I want to talk about here, the whole thing about a birth certificate, or you said it's a death certificate straw man. I have spoken about this with Rule of Law radio show host Eddie Craig in my interview with him. And by the way, just let me throw it out. Everybody should watch Eddie Craig's masterpiece presentation, Secrets Police Don't Want You to Know, on the Alex Jones channel. You won't pay traffic tickets ever again if you follow the advice in that video. But the thing Eddie Craig says that a lot of people are scratching their heads about, he asserts that the whole thing about a birth certificate straw man is a lie. He asserts that when you go to court, all they're doing is accusing or alleging that you committed an infraction in a commercial capacity over which there exists some government regulatory authority. He asserts that that's all there is to it, and you can prove that through the statutes and the codes that they're saying you did something in a commercial capacity. And he says that when they put your name in all capital letters on your birth certificate, they're not turning you into a corporation. You're not representing a straw man. He says that is just a patronat myth. But other people, including you, would assert, no, there really is something to the birth certificate straw man thing. So can you debunk Eddie Craig and all the other people who say it's a patronat myth and say that the birth certificate straw man and the thing about putting your name in all caps to make you a corporation is true?
I would not try to debunk anyone. Some of the conclusions that we arrive at depend on where we start our logic at. And so rather than try to debunk or to, take something else apart, I'll be happy to give my understanding, from my point of view, and just basically say where I have started from, if it makes sense to the people. And so maybe we can trace the history of that in conjunction with what I have already alluded to here with these three different periods of national bankruptcy. Because when we get down to the period of 19 and 20, I think a lot of these things were anticipated. And so when we get down to the period of 1920, 1922, there are some significant events. Certainly in 19 and 20, the cabinet position, which was known as the Secretary of the Treasury, was removed from the cabinet, and it became an international organization. Now, that's very significant. And also during that period of time, perhaps in anticipation of how the system was going to evolve eventually over the next, 10, 15, 20, 30 years, there was a certain social movement that became very popular. And I'm just trying to think of it's called the Townsend-Shepard Act, as I recall. But it had to do with basically the abuse of children in sweatshops. In other words, children were put to work, they were forced to labor, long hours, blah, blah, blah. And the general consensus of the society was that was wrong. That children should have an opportunity for a childhood and they should not be involved in slave labor. So from a social point of view, there was a great deal of interest in that situation. Now, as a result of, or perhaps in conjunction with, that movement, that social movement, and also legislation that followed, it was suggested that the children should be registered. Now, this is an important concept, as we'll see here in a moment. But in essence, the registration of the child into the commercial registry created an exemption from taxation. So let me just run through how that would work. When a child is brought into this world and breathes the breath of life, in other words, they're alive. And now I'm not talking about a stillborn here. I'm talking about an infant that breathes and is living. First of all, the mother delivers the baby into the state official's hands, who is known as a medical doctor who is operating under a license from the state. And so I'm kind of giving a little bit of symbolic representation here. So the mother delivers the baby into the hands of a state official who is licensed to do certain things. Now, following that delivery, an application is filled out by the mother, wherein she makes an application for a live birth. Now, generally we spell that BIRTH, but for consideration here, what if it were spelled BERTH? And so that application for a birth is the entrance of the baby into the Admiralty. Now, this application for a live birth is a very significant document, in as much as if the state, I'm just using the state now in a general sense. When I say state, I'm talking about government generally. So if the state then has received the baby into a safe birth or into a safe harbor, then the state has to provide safety, safe harbor for that baby, and they do. Now, it's the registration of that new infant into the commercial registry that creates what we would basically call a foreign situs trust. Now, the way that trust is funded is that the application for the live birth goes through the commercial system, through the Department of Commerce, and ends up in a private company, which is known as the Depository Trust Company of New York. And based upon those commercial documents, the DTC, the Depository Trust Company, creates bonds. Now, a lot of people have got their mind twisted about this, and so let me dispel some of that twist here real quick. You know, the bonds that are created do not belong to the people. They belong to the company that created them. The bonds are put in place to guarantee the discharge of debt. That's what they're there for. And so people got the bright idea, wow, look at all that money DTC has created. It ain't yours, folks. First off, it's not money. It's bonds. So those bonds are used to guarantee the discharge of debt by the citizens, and the new baby being allegedly a 14th Amendment citizen. And I can go into that just in a moment, perhaps. But anyway, those bonds are created to guarantee the discharge of debt that will be accomplished by that infant as it goes through its life, as it grows up into maturity until the day that it dies. Now, that is what is known as a foreign situs trust. And it is in place. It was put in place. It was the trust that had to be put in place to guarantee the safe harbor, the safe birth for that infant, and all through its life. Now, if the infant, reaching the age of majority of 18 years, decided to opt out of that system, they could at that time. Most people do not. In consequence of that, legally, if you're 40, 50, 60, or 100 years old, and you have not done anything to the contrary, you are still legally an infant. And as an infant, you are a ward of the state. Okay, so I hope people can kind of see that now, how that comes about. All right, now, let's talk about the concept of subrogation. And here's where the birth certificate comes in. The birth certificate was not created when the child was actually breathed the breath of life and was delivered to the doctor. The birth certificate was created in consequence of that. And the birth certificate, at least in my case, in some states it might be a little bit different, but in my home state of Kentucky, the birth certificate was created by the state registrar. The state registrar was the one that created the birth certificate. Now, on the birth certificate, they carried over the registration numbers from the certificate of live birth. They carried those numbers over onto the birth certificate itself. Now, on the certificate of live birth, the name that my mother gave me is written properly. Actually, mine was written in cursive with upper and lower case according to proper rules of grammar. But on the birth certificate, which was created by the state registrar, that name was converted into all capital letters. Now, the reason why they did that is easily explained. If you want to go and study the United States Styles Manual, and I don't have the exact reference on that, but anyway, in the United States Styles Manual, it indicates that anything written in all capital letters is one of three things. Either it's a U.S. vessel, or it's a corporation, or it's a dead person, or D, all the above. Okay, so the birth certificate itself created a fiction in law. Now, is that a good thing or is that a bad thing? I mean, it depends, again, on your point of view. But let's look at the implications of that. Now, if the birth certificate had have been created and simply sat there for 100 years and nobody did anything else about that, it would have absolutely no effect. But people are induced to subrogation. They're subrogating, their benefits from the foreign situs trust into a new trust. And the way that they do that is they are induced to fill out another application, which is known as a Social Security Form 5. Now, the Social Security Form 5, or the SS5, is an application for a Social Security account. And as a result of that application, an account number is issued to that party. Okay? Now, a lot of people are confused about this. So what they're calling the Social Security number is not from the Social Security. It's actually issued, by the IRS through the IMF, which is authorized by the United Nations. And so that's where that number comes from. Now, when you subrogate, what that in essence means is that you are giving up your rights and defenses based upon your signature. And so what rights and defenses that the people had under the foreign situs trust became subrogated to a cestui vi trust, and the implications that have come from that. Now, we could go and spend a lot of time talking about signatures and how we sign things and the implications of those signatures without putting any kind of restrictions on the signature and so forth. But in essence, most people simply, like I did when I was 15, I went down and filled out the form and just signed my name. I didn't know any better. But in any event, because of that signature on that form, I, in essence, subrogated the rights and defenses I had on the foreign situs trust, which included an exemption from taxation, along with all the other things. So I subrogated those to the IRS/IMF/United Nations. So that's exactly what happened. Now, because of that signature on that SS5 form, a certain power of attorney is assumed by the IRS, IMF, United Nations. And also, because of the implications of that application, I am construed to be the trustee for that account. And we could go into a little bit of trust law, certainly like how Dean does it, to explain some of those things. But in any event, the reason why I'm bringing this up is that because, of doing these things, then people find themselves in the circumstances that they find themselves in, and in consequence of that, we have the problems. Now, are those problems correctable? And the answer to that is yes, they are correctable, and there's certain techniques and technology and so forth that could be used to rectify that problem. But in any event, I just wanted to explain the birth certificate from that point of view. Now, in the past, I have referred to the birth certificate as a death certificate on the basis that if you go out to the cemetery and look at all the names on the tombstone, you will find that the name is spelled exactly as it is on the birth certificate. Hence, the birth certificate could best be understood as the assumption of death. Now, for those of you who understand about the purpose of the county coroner, only a coroner can actually declare a body to be physically dead. Hence, the birth certificate is an assumption of death. It's an assumption of death, you see. Now, assumptions can turn into presumptions in a civil matter and so forth. And so, anyway, does that kind of help?
Yeah, yes, it does. We'll probably get back to that thing about Dean Clifford and trust law in a bit, but there's something I do want to talk about, because I remember in the not-too-distant past you did a interview about this, which can be seen on the N5D YouTube channel, and I'd like to give a little story about something that happened when I called into the Rule of Law radio show and spoke to Randy Kelton about the thing known as the One People's Public Trust. Okay, here we go. I called into the Rule of Law radio show and asked the host, Randy Kelton, if the One People's Public Trust was worthwhile, and I explained to him that the people behind the OPPT, the One People's Public Trust, they foreclosed, or more specifically filed a lien against the banks and the corporations and all the governments that masquerade as corporations. And Randy Kelton, before I could finish explaining, he said, whoa, I got to shut you up right now. We've been down this road before. And he said, first of all, the stuff about the OPPT talking about the creator granting you rights, it's kind of beside the point. It may be true, but you cannot invoke God in a court of law. Don't even think about that. So right there, the OPPT falls apart. And he also said that you are basically wasting your time trying to file a OPPT document to get out of legal issues. You're guaranteed to go to jail if you do. The banks and the governments are too corrupt to even take this seriously, and even talked about how a guy tried to file a lien for against the government and the judges for transportation, because you're not in transportation unless you're in commerce. And Randy Kelton said, sir, what were you thinking? Did you think they were going to roll over for you? You're going to be in a hell of a lot of trouble just because you filed this lien for transportation. And the same thing he said would happen if anyone tried to use OPPT documents to get out of trouble. But I seem to remember in that interview, I do remember this, he actually made reference to you, Randy Kelton did, and he talked about, and you probably remember this better than I do, where you were explaining something about the law, and you eventually admitted that you made the law up at some point. You probably know what that's better than I do, but Randy Kelton said the point is you can't just expect them to roll over you by filing documents that invoke God. You have to play the politics and make reference to statutes and court laws in a court of law if you expect to win the case, and he asserts that we have what we need at our disposal to do that. But the OPPT, in that interview you did, you basically said, now who died and made the OPPT God? That in a nutshell is what you said. So why do you believe
said, all right.
Yeah, so why do you think the OPPT is not worth it, aside from what Randy Kelton said? They're not just going to roll over for you like that.
Well, first, let me say this: that I'm not particularly antagonistic toward anyone who will try to inform the public, with this exception that the information that they give, should be correct, so as the people will be benefited from it rather than damaged. The UCC filings that I saw, that they put forward that they had done were done on national form, and the national form is not a lien. Now, it may have some sort of a notice that a lien may exist, but the UCC one on national form is not a lien, and I really wish they had consulted with me before they took off on that journey. The only UCC filing that creates a valid lien is a state form that is not filed but recorded in the county recorder's office. The county recorder's office, if people don't understand, that is the seat of government, the county. And in consequence of that, a UCC-1 financing statement, which is recorded, as I did in my home county way back in 2000, that in fact creates a valid lien. And so they kind of got off on the wrong foot, when they started that business and so forth. And I think that it led to misinformation, whereas they were perhaps referring to things that simply were not correct. And so, for those reasons, the thing was flawed right from the very start. Not to cast dispersion upon the efforts of those who were trying to work those things, but really, I really wish that they had come to me before they started that business. I think I probably could have gotten them going on a correct direction by using correct concepts.
Okay, well, forget about that for a moment. Okay. I'm sure there are going to be some people who try to file OPPT documents, and they're going to find themselves in jail for 6 years. Hopefully, I'm wrong about that. But I want to talk about something involving corporation. You did mention in your earlier in your talk about how the Articles of Confederation did create, so to speak, a corporation. And I've heard you say that the United States government was always a corporation even before it became a corporation shortly after the Civil War. And the fact is, the United States Constitution for the United States of America was switched to the Constitution of the United States with a capital letter U and United and S in states after the Civil War. And that does tie into the 14th Amendment citizen thing. The 14th Amendment does not mean what a lot of people think it does. And you said you could talk about the 14th Amendment citizen thing. So please talk about that. And also, what did you mean exactly when you said the United States government's always been a corporation?
Well, if you look at the definition of what a corporation is created to carry debt. That's what a corporation is put in place for. A corporation is a straw man. It is a fiction. And so when the Articles of Confederation were conceived of, it was at the pleasure or at the insistence, I don't know which one, of the various states. At that time, there were 13 of them who came together and said, look, we have these debts outstanding that we cannot deal with. Let's incorporate and transfer the liability to the corporation, which they did. And so the Articles of Confederation then became the first bankruptcy, of the people here in North America, or at least the Europeans who came here, and so that's what that was for, and so it was always a corporation. Does that make sense?
Hey, Winston, you there?
Yeah, I'm here.
Yeah. I just while you were talking, I quickly wanted to run to grab a book because there's something I want to talk about later on. But I am back. I'll make sure I re-listen to what you said earlier. So, all right. But one thing I want to talk about again, the subject of regulating commerce, because in my interview with Eddie Craig, I asked him where did the government's authority to regulate commerce come from, and he admitted that the authority to regulate commerce was interpreted by the courts through the one and only reason why government was created, to exert by any force to protect the rights and property of every single person under the auspices of that government. And the thing that really struck me there was he admitted that the authority to regulate commerce was interpreted through the courts. Now that's intriguing because case law, as well as statutes and ordinances, are not actually laws. They are what someone in the government or courts considers to be public policy. Therefore, the government's authority to regulate commerce is an illusion. But the reason it's accepted is because the people, because they felt that they needed to protect themselves. They needed the government to protect them from some outside threat, in this case commerce going on around them by people who were exploiting resources and such to take money for their business. That's why the government has authority to regulate that. But that's really intriguing because many people don't look at this. Some people say, oh, no, that means the courts can do whatever they want. They can decide whatever they want. And, well,
okay,
no.
Okay, let me break in here and go back a couple of steps. And that is the thing that motivates all people to do commerce or to do any kind of interaction or interchange is based upon a contract. And so two people say, well, we want to do this or that, and so they enter into a verbal or written or whatever kind of contract. Now, as long as the contract itself is abided by both parties or all parties, as the case may be, there are absolutely no problems. The only problem comes in is when one party of that contract goes into breach of contract. Now, the breach of contract gives rise to law. Law is not, the first thing in the equation. It's the contract that is the first thing in the equation. If there is no breach, there is no law, because the law is the remedy to resolve the breach. And so all these law books and libraries and stuff we got all across the planet here, what they are indicating is that the people and so forth are in breach of contract. So the real issue is, let's go find the contract upon which the allegation of breach has been made. And that's where all law arises from, is as a remedy for the breach of contract. So you have to go back. You have to go way back to find out what is the original contract. If there is no contract, there is no law. If there is no breach, there is no law. Law is only created to deal with breach of contract. Does that make sense?
Yes, it does make sense. And getting back to what I said about running to get that book, I found the page in the book here I wanted to talk about here because it talks about something. This is actually David Icke's book, The Perception Deception, by the way. I'm about two-thirds of the way done reading it. I encourage others to read it too. But the thing I want to talk about is his definition of derivatives, because I remember in an interview that you talked about not that long ago, you defined a derivative as something that people will seek and keep working for if they know that they will get it if they work for it, like numbers on a paycheck as their money, among other things. But the definition that Icke gives in his book here is a simple but less than full explanation of derivatives is that it involves fraudsters hedging their financial bets by scamming someone else into taking their risk and selling the same financial products to multiple buyers who all think that they are the only owner. And I'm sure that you can find a way to tie that into what your definition of a derivative is, but many people would say you would need at least 15 minutes to define what a derivative actually is. So tell us what is a derivative.
It won't take me 15 minutes to define a derivative.
Yeah, okay.
A derivative is anything other than zero.
Oh, okay. Elaborate, please.
No, well, if you look at nature, and as I've said, so many times, that any system of commerce, government, or whatever, if it duplicates or if it mimics the laws of nature, it has a chance of being successful. If it goes against the laws of nature, it will surely fail. Now, if you look at nature, you see certain things, and that is that there's a certain desire or a certain direction to reach what we call homeostasis, and that is everything being level. I mean, the mountains erode away, and the rivers run downhill into the sea, and you see these cycles of nature and so forth that go on. And so that's why I said that a derivative is anything that's not zero, because zero is the ultimate homeostasis that we're seeking for. Even nature seeks it out, and so we ought to imitate nature. Now, in our commercial dealings, because we have moved into accounting for fairness. In other words, for every contract, for every interchange that people do, we're always interested in making sure there's a fair deal. And so that's what we're trying to get to. Now, how do you determine whether or not there's been a fair deal? And the answer is it's within the accounting. Now, if you get into our present accounting system under GAAP rules and all those kind of accounting procedures and so forth, you understand that we're operating with what's called double entry bookkeeping. Now, the purpose of the double entry bookkeeping is to determine, has there been a fair deal done? And the only way to determine that, yes, there has been fairness is if you have a zero balance. The zero balance will demonstrate that fairness has been achieved. If the ledger shows anything other than zero, now you have a derivative that you have to deal with. And so I think that short explanation should pretty much sum it up.
Yes, but I'm sure a lot of people will try to make the description a lot more complicated than it has to be. But
yeah, the accountants and lawyers generally do.
Yes. Okay, one other thing I want to ask you about, the word Commonwealth. I remember in an interview you once said there are significances behind a state being called a Commonwealth, but when I asked Eddie Craig about that on Facebook, he did some history writing on Commonwealth, and he eventually came to the conclusion that no, there is no significance behind the name Commonwealth. That's just a fancy word that's used in place of the word state. Well, you stated otherwise. Why do you believe there is some significance behind, like Pennsylvania and Kentucky and such, being Commonwealths?
The concept of Commonwealth is a carryover from the feudal system. It also deals with titles, and maybe I can describe the feudal system so that it's understandable in our modern use of the word Commonwealth. Sure. And that is back, centuries ago, when the kings of England and Europe and so forth came up with a bright idea, that they were infallible, and that the kingdom, the land, the resources, and so forth belonged to the king. When people bought into that idea, if they wanted the use of some of the king's land, they would go to the king and petition for the use of that land. And the king would say, okay, you can use the land, and I will give you a title. It might be, I don't know, Earl or Baron or Lord or whatever. I don't know exactly what those classifications were, but attached to the title was the three following things. Number one, knight service or what we call military. You know, some of us old-timers actually got drafted, if you recall. In any event, night service, number 2, was rent for the land, and number 3 was a tax upon the product from the use of the land. So you got a title, you had to pay rent, and you had to pay tax on the crops. Now that was the feudal system, and that is the genesis of what we call commonwealth. And so as a result of the mindset of the English and some of the other Europeans who came here, you know, they were trying to escape from that system, but upon upon coming here, they brought it with them. So immediately, when they would go and steal land from the native inhabitants, the first thing they would do was set up a title office. So they could claim exclusive use of that land. And so that is the genesis of why many of the original states referred to them as commonwealths, is because they imposed the feudal system upon the Europeans who were seeking a title. The native people had no such system.
Okay, I think we might as well take this moment to talk about the whole thing with trust law, because Dean Clifford's presentations, they do base themselves on the idea that the birth certificate straw man is in fact true, and trust law, like I said earlier, is a form of maritime commercial admiralty law at some level, but some people, including Eddie Craig, I keep making reference to him, but it's just that his material kind of ties in with what you're talking about, so it makes sense to. He has talked about how Dean Clifford's method, it's not in your best interest to use that. It may get you out of any trial without being charged with a crime, but in the end, you're just going to keep getting arrested over and over, and Dean Clifford has gotten arrested over and over and over, even though he always manages to get out of the court without getting any charges pressed against him, and Eddie says that's a bad way of doing it. So get into Dean Clifford's trust law method for a little bit, and do you really think it's worth it to try his method?
Well, I'm not sure what Dean's method is. I mean, I know Dean. I mean, I've known him for a number of years. And so I'm not really sure what you would call the Dean Clifford method, so much as he goes into explaining the system from a trust point of view. And so if you would like for me to discuss, the system from the point of view as being a trust or a public trust or cestui vi trust or whatever, I'm willing to do that. But I really couldn't expound on Dean's method because I don't know it.
That's all right. Just from what you know, I shouldn't use the word Dean's method. It's just that that's the method he uses. So people acquaint him with it. So
okay.
Talk about it.
Yeah. Let me just give this one maxim. That people should understand, and that is, any time the outcome is uncertain, there is a trust created. Now, because basically because everything is uncertain, then everything that we do is based upon a trust. For instance, when a baby is born and it starts to live, how long will it live? No one knows. And so the very life of the baby and of the teenager and adult and the old timers and whatnot, it is still a trust because no one knows the day nor the hour, when they will die. So basically, then everything that we do upon this planet is a trust, and so it would be wise to understand, how trusts work. Now, there are certain implications of trust law and so forth that get people confused, and because they're confused on those issues, then they perhaps are a bit misused. And so, it certainly behooves everyone to understand, a little bit at least about how trusts operate and what they can expect, from that trust. So basically, a trust The party that creates the trust is known as the grantor or the trustor or the creator. Now, for all the folks, that follow religions or involved in theology and so forth, we refer to God as the creator. And so that's a good analogy that we could use to explain some of this. For instance, we say, well, God created the earth. Great. And so we're here upon this planet as the beneficiaries of that trust that God created, if you want to put it in those kind of terms. Now, we also have sub-trusts that are set up for a variety of reasons. And the party that instigates the trust is called the grantor or trustor or creator. Now, there's another element in there that people have to understand, and that is the position of settlor. The settlor is the party that brings the asset into the trust, which is known as the trust corpus, and the settlor may or may not be the creator. And it very well could be, but it's not necessary. Okay, so now we have the creation of this trust. There is a trust asset that is involved, and let me just point out, if you try to create a trust with no asset, then it is not a trust. So there has to be something of value to constitute the trust corpus. Now, the other elements of the trust are basically two things, which is, number one, the trustee, and number two, the beneficiary of the trust. The trustee is an appointment. The trustee has the legal responsibility to settle all the liabilities of the trust, for which they receive a wage. Okay, so they don't do it for free. They have to be paid. Now, when you get to the beneficiary is the party for whom the trust was created. Now, if you look at the breakdown, the trustee could be classified this way. The trustee has the legal title to the trust corpus. The beneficiary has the possessory title or right to the trust corpus. So it's the duty of the trustee to disperse the trust corpus to the beneficiary as it is prescribed in the law of the trust. So that's how the thing operates. Now, it is possible for the creator to also be a beneficiary. It is not possible for the creator to be the trustee. Otherwise, why would you have a trust? Because that's an obvious conflict of interest. So the creator could be the beneficiary of that trust. And if you want to go back into religious, jargon and thought process and so forth, you find Jesus Christ showing up on the planet as a beneficiary. So we have the creator acting in the capacity of a beneficiary, if that makes any kind of sense. But most respects, then, that's how a basic trust is set up, and then depending upon the law of the trust that is created, then you have that. Does that kind of make sense? Do you have any questions about that setup?
Not in particular, but one thing I do have some serious questions about is I recently listened to that interview you did with David Wilcock back in May 2012, I believe, and Wilcock, or whoever made the video, called it the legal basis behind the mass arrests, and mass arrests refers to, they never actually happened, but they refer to the mass arrests that insider Drake Kent Bailey talked about, how eventually tons of people in the government would be getting arrested, and moles within the Pentagon and other government agencies that Wilcock says do actually exist. There are moles there. They're going to help with these mass arrests, and you explained how the Pentagon would in some way help with these mass arrests, and you explained the whole legal basis behind it. Well, many people probably say the Pentagon is not going to give up that easily, and any whistleblowers are going to get killed before they can do anything. I don't know if the mass arrests are unavoidable. I mean, the New World Order can never take over because, metaphysically speaking, Earth is a love-based planet at its heartful essence, so says George Kavasilis. But the point is, these mass arrests, do they have to happen at some point, or have you changed the way you look at them?
No, I haven't changed my opinion of that at all. I do have some evidence, which I'm not willing to, broadcast, that arrests have and are taking place. Whether you want to call that a mass arrest at this point is kind of doubtful, but in order to correct the system, they have to remove those who have caused the problems. Now, the reason why the Pentagon, which controls the military, would be involved in that goes all the way back to the Civil War. Well, as I mentioned, the federal government had won the war against the states. The military, all of the states at that point, and all the states that came in later. And by the way, there's not 50 states. There's I think 56 or 57 states. You got Puerto Rico, Guam, the Mariana. I mean, you have there's a whole bunch more states than just 50. But in the corporate United States, there's more than 50 states. But in any event, the U.S. military is a occupational government, and they operate as under military occupation under what is known as the Labor Code. Now, since the Civil War, all civil government has been instituted by the U.S. military. That's who is responsible for all the municipal governments. And so it is only natural that if the civil government is not functioning properly, who would correct that problem? It would have to be the military. I mean, we can call them the Pentagon if you want to or whatever. But anyway, if the civil government has gone awry, however you pronounce it, then it's up to the military to correct that problem. Now, is the military correcting that? And the answer to that is yes, they are. And, I mean, the indications are that I've had for a very long time, and Drake as well. I mean, Drake was talking about seeing certain documents all the way back to 1975. I mean, I don't go that far back with the information that I have, but certainly I go back a number of years with information, that has come to me from reliable sources. And the indications are that an interim government has been created, and the indications are that interim government, sponsored by the Pentagon, will in fact come forward when we have successfully reset the currency. Now, the currency is being reset at this present time. The only thing that stood in the way of it is the United States Incorporated. The CEO and the treasurer of that corporation have been able to successfully block this up to this point, but that is soon to come to an end if it hasn't already come to an end. And so again, when the currency reset has been put into effect here in the United States, and we have a new currency, having gotten rid of the Federal Reserve notes, at that point the currency will be issued under the authority of the new republic, which is an interim government which has been created by the U.S. military / Pentagon. Does that kind of make a little bit of sense to you?
Yeah, it does, and I'm glad you talked about that. Even if you're not at liberty to talk about the fact that mass arrests are going on and naming them, it's some people will probably breathe a sigh of relief to hear that some of your sources are saying that's happening. We are undergoing a major consciousness shift, so to speak. Alfred Weber, Franco De Nicola, and other people that have come on my show have talked about how up until 2017 we'll be going into 5D consciousness. Not all humans will go along for the ride, but those of us who are awake are in for a ride, and we should all definitely live our life to the fullest to make the best of it.
Correct.
Yes. One thing I do want to talk about here, let's have a little fun here, turn this into a little debate between Dean Clifford and Eddie Craig. What I'm talking about is Eddie Craig, in his method of fighting traffic tickets, he asserts that when you're fighting a traffic ticket in court, he has his own script for what you should say if the police pull you over, stop you at a checkpoint. But if they try to take you to court, he says, don't argue the merits of a case, just use the argument, I was never engaged in transportation in the first place because I was not operating in a commercial for-hire capacity, therefore I cannot be charged with this crime. And he says that's the best way of doing it, but I remember Dean Clifford in one of his talks saying that it's not the best way to do it, to use the argument, I was not operating in a for-hire commercial capacity, so I can't get this. Traffic transportation laws only apply to commercial drivers. Well, the thing is, I do remember Eddie Craig on his radio show talking about how a judge in Texas, a guy did try to use the argument, I was not operating in a for-hire capacity, and the judge in his final say or whatever you call it, he basically made a total fool of himself, the judge did. He said, the defendant is making the absurd assertion that he cannot be charged with this crime because transportation laws only apply to commercial drivers. If this were the case, there would be chaos in the streets. A commercial traveler, he actually used that phrase, commercial traveler, the judge did. There is no such thing as a commercial traveler, legally speaking, and he said some other things in his speech that showed that this judge has no idea that the legal definition of a word is different than the standard English dictionary definition of a word, but that's not really the point. The point is there's a debate between Eddie Craig's method of saying I was never engaged in transportation in the first place, and Dean Clifford saying, no, it's not in your best interest to use that method. You should use, well, the method he uses. So whose method do you think is right, and why would you say they have the proper method?
I probably would not. You can take either of those ploys. I mean,
okay.
It's kind of like this, as a carpenter, I had a toolbox that had a lot of different tools in it. Now, for a specific job, there was a tool that was the best to use for that particular operation. For instance, I had a framing hammer, I had a finish hammer, I had all kinds of different hammers, and so depending on what particular job I was doing, then I would pick that particular hammer. And I think kind of maybe perhaps, with some of these different methods or different tools that various ones are suggesting, the listener is at liberty to pick whichever tool they think. For instance, I would not use a finish hammer to drive 16-penny nails. I use a framing hammer, but you can still drive a 16-penny nail with a finish hammer if you want to. And so then the people are at liberty to use, whatever method that they would find most suitable to what tools they have. And so I'm not going to, pit, one party against the other, in that respect, other than to say that it depends upon the education of the party that's using the tool.
Okay. There are different ways of doing things, and I guess if it's not broke, don't fix it for some people, depending on their method. But one thing I do want to talk about that's many people assert we shouldn't talk about this because this is a bad way of looking at it, but others say, no, maybe it is a good strategy. The whole idea of exposing the fact that the Constitution does not actually exist. If you've read Lysander Spooner's book, No Treason, you would know that the Constitution, even though the Founding Fathers had good intentions, they did not pass the Constitution with the consent of the common people. Therefore, it is and always has been an illegal document, and the same can be said with the majority of the state constitutions, and the tyrants in the U.S. government are very well aware of this, and they're using this to their advantage by scamming the American people into believing the Constitution exists by making reference to the Constitution and taking an oath to defend it. They do while simultaneously violating it without consequence. But ironically and paradoxically, they're also trying to brainwash the American people into wanting to get rid of the Constitution and thinking it's outdated, even though they know it's never actually existed, the powers that be do. And some people say that we should expose the fact that the Constitution is an illegal document because it would expose the fact that the government is playing us for a sap. Now, you've made a lot of reference to constitutional law and reverting back to it in your talks, but in a sense you're saying, well, let's revert back to something that doesn't actually exist. So what's your take on the whole idea of the Constitution being illegal, and what would we do about it to expose that, if we should expose that?
I think really the discussion should center itself with constitutional principles. and that is, common sense, reason, and logic of how to solve problems. Now, the written document, which people refer to as the Constitution for the United States of America, was not a binding contract upon anyone. In essence, the only binding contract that we have is the Declaration of Independence. Now, that is binding as we accept that pledge. And so the Constitution itself, was developed in secret. Nobody signed the thing. They came out and declared, and brought it out and so forth. And so it became functional as the people acquiesced to it. But again, if you look at the Constitution itself and look at the oath that is supposed to be taken by the party who fills the office of the President of the United States of America versus the oath which is taken by the President of the United States, you see two various things. The one in Article 2 of the Constitution is one oath, and then in Article 6 it has the oath for the party that fills the office of the President of the United States of America, which no man has ever taken in our history. No man has ever done that, including George Washington. Now, they've all taken the Article 2 oath, but they could not have taken the Article 2 oath unless somebody had taken the Article 6 oath first, because the party that fills the office of that takes on the responsibility of the President of the United States is an appointed office. Now, Washington himself always took the Article 2 oath. Every president since that time, including the one that we presently have, took the Article 2 oath, but they took the Article 2 oath illegally because they had no appointment to do so. And so, I'm not screaming fraud on all this, but it's been historical that that's the way that it has happened. And so far, since the Constitution for the United States has been in effect, we have not had anyone who has taken the Article 6 oath. Now, under the Articles of Confederation, we did have, I think, 7 or 8 presidents under the Articles of Confederation. George Washington was not the first president. He was the first president under the Constitution for the United States of America. But the other presidents we had, at least 2 of which were African descent. And so, with Obama going around, everybody claiming, hey, the first black president, and of course that's pure BS. We had at least 2 prior to him back in the days of the Articles of Confederation. So people really need to go and study their history a little bit and get their thought process moving in the right direction. But Lysander Spooner was absolutely correct. And people need to go read, what he had to say about that. Spooner was a lawyer. He was not an attorney. He was a lawyer. And he understood the law very well, certainly the law of contracts. And when he talked about the Constitution of no authority, he knew what he was talking about. But by general consensus of the people, this is how we have operated. And so if that's what the people want, then that's how we'll operate. I'm not here to tear down the Constitution or anything else. I'm just saying that we have not abided by our original contract, which was a pledge that was created under the Declaration of Independence, which was signed.
Right. A lot of people don't seem to understand that rights are granted by the Creator, or the Constitution simply states rights you already have. So there's no reason to freak out over the fact that the Constitution doesn't exist. But still, the fact that we acknowledge that it exists does mean the government has basically 19 powers. One is to use by any force to protect the rights and property of everybody under the auspices of that government, and the other 18 powers are the 18 enumerated powers in the federal Constitution. But speaking of which, one enumerated power in the federal Constitution that has been so highly abused is the Commerce Clause, to regulate commerce among the several states with foreign nations and with the Indian tribes. And in my interview with Eddie Craig, he talked about how the only authority to regulate commerce that the Founding Fathers wanted the government to have had to do with ships from other states going into ports and the states using to their advantage to screw over the ships that were docking in those ports. I don't remember off the top of my head exactly what he was talking about, but maybe you know what he was talking about. What was the purpose of the Commerce Clause based on your understanding?
You want me to tell you what I really think about it?
What about it?
It was put in place so that one merchant could screw another one.
Oh, okay. Why do you believe that?
just look at the results of it.
Well, yeah, but the whole thing is, and I was at a John Birch Society meeting where we discussed this very subject, the guy asserted, no, the Commerce Clause was not put in there to say, well, you're growing a vegetable garden on your property, and the fact that you're growing a garden means you're growing food for yourself, which means you won't buy at the store, and the fact that you don't buy at the store means that you're affecting commerce so we can regulate you. No, that's not what it was meant to do. It did have something to do. Do you have any idea what Eddie Craig was talking about when he talks about how it has to do with ships
when
docking?
you get into those kind of discussions, you're talking about fictions, and I'm not against fictions. They're very useful in their place. However, if you want to talk about in regards to commerce, if you want to talk about substantive law, then go study the law of merchant law. The law of merchant law was substantive law. But all this commerce stuff and all these statutes and codes and constitutions and on and on and on it goes are simply fictions that the people acquiesce to because they do not invoke a substantive law. And again, where does law come from? It comes from breach of contract. If you don't go back to the original contract, you don't have any reason to talk about law.
Well, your statement about law being breach of contract, Eddie Craig has
the remedy.
In my interview with him, he asserted that there are only three things that can be called laws. One is the federal Constitution as it exists, not that it does, but as it exists. The state constitutions as they exist, the vast majority of them are illegal, and also bills that are signed into law by the governor after they go through all the proper legal channels. Do you disagree with that based on your definition of a law or not? Yes,
I disagree with that very much so. When confronted with this same question, the master said there's only two laws. Number one, in essence, was to love God, the Creator, and number two, to love your fellow man as yourself, and all the other laws, statutes, codes, blah, 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 hinge upon those two things. Now, all these statutes and all this business, all these law books and these libraries and these precedences and all this foolish stuff, if they do not comply with those two things, then they are of evil. Period.
Right, and it's been said that when it comes to the question of what are your rights, the answer is you have the right to do anything that does not result in you causing harm or intending to cause harm to another person or property through either negligence or...
Exactly.
Yes, right, through either negligence or deliberate intent. And it has been said that the government's authority to regulate commerce is directly correlated to that because you cannot expect to run a business in which you make a profit and in the process of making a profit take away from the resources of other people because you are, in a sense, committing harm by running that business because your business gives money to you, which means there's less money for other people. So would you agree that that's the proper way of looking at it in regards to the government regulating commerce for the sake of preventing harm?
Yeah, that seems reasonable, yeah.
It does. But how do you propose we go about? I might as well talk about some remedies. I can only give you about 10 minutes, but in regards to the remedies that you like to talk about, quickly, briefly summarize to the best of your ability, what are the solutions in commerce that you like to talk about?
Well, when I first started on that journey, as a young person, one of my areas of study had to do with the concept of free will. And, as a teenager, I took a particular interest in that. As teenagers do, we're always looking around at the world trying to figure out, what's what and how the things get to be the way they are. And so I did an intense study of the concept of free will, the different ramifications of it, the restrictions on it or whatever. Now, with that in mind, it became obvious to me as an adult that this planet was created as a free will planet. And my studies have, indicated that over and over again. All right, so if the Creator intended that mankind should have free will, what's the problem that we don't have the free will that we have been granted by the Creator? And the first thing that came to mind was debt. Debt is a 4-letter word. And so in an effort to liberate people so that they could exercise free will, then the effort was made to demonstrate solutions to the problem of debt. And so that's been the direction that many of the technologies, techniques, and so forth have been directed to. Now, along with that, there has to be a certain amount of understanding. And one of the things I found real quick was that people don't understand what money is. How is it created? What is it? Where does it come from? Where does it go? And people are misled generally about money. In particular, what we would call private versus public money. Now, one of the good studies, as a matter of fact, I put out a single topic DVD on this very subject, which was money of exchange versus money of account. And what people are getting confused about is the difference between those two. Now, when you get into the public, you are only dealing with money of account. That's all. And money of account is non-cash. When you're dealing over here in the private side, between your friends or whatever you're doing out here in your community and so forth, that is money of exchange. It is cash. But in regards to anything that's in the public domain, it is always non-cash items, money of account. And so people are tricked. People are fooled. And the CAFR accounts are full of money of exchange that people have been tricked into giving up when money of account was called for. And so when we start talking about money of account on the public side, we're starting to talk about adjustment of accounts using negotiable instruments. One of the first things I studied when I launched off into this world of commerce was I actually took a college course about negotiable instruments. Negotiable instruments are non-cash items. Negotiable instruments, there's only two kinds. There's promissory notes and there's bills of exchange. And so both of those qualify as non-cash and are to be used in the public for settlement of accounts. The settlement has to bring the account to zero so that you have harmony, so that you have equity, so that you have fairness. And so what happens is that people, because they don't understand the difference between those two particular types of money, are enticed or tricked or extorted to apply cash to a non-cash transaction. Now that really creates a problem under the Trading with the Enemy Act, because it's against the law to do that. That's why everybody is considered to be enemy combatants and fall under the Trading with the Enemy Act. And so people really need to get that money thing sorted out and figure out the different forms of money and what type of money is to be used in any particular situation. Does that kind of help?
Yeah, and just as a side note, Alex Collier has said that Earth is the only planet in the Milky Way where the inhabitants use money. Well, that makes the whole thing a lot more complicated now, doesn't it? It proves that Earth is a slave
it
planet.
actually simplifies it. That was the purpose that I created that other website, which is exocommerce.net, was to demonstrate that we do have the technology to put us in a position where we could do commerce with people from other planets. It is true, as Collier says, they don't have banks, they don't have hoarding, they don't have money, and so the purpose of ExoCommerce was to convince people, in reference to the technology that I had with Solutions in Commerce, that it is possible to operate from a non-cash position. And once you can learn how to successfully operate in this world in that manner, then you could, in fact, do commerce with people from other planets who operate in that manner where they come from.
Okay, I might as well do one more subject here. I can give you
Okay.
a little over 4 minutes. The whole thing about Santos Bonacci, I know you had him on. You were on his show, and he's right now in a lot of trouble because he isn't paying his toll fees. Now, he, as a non-commercial traveler, he is not required by law to pay tolls. But the thing about his case is he's basing his defense on the whole birth certificate straw man thing being real and filing documents which he claims puts you in the land of the living because he says the birth certificate is a death certificate. I can give you 3 minutes and 45 seconds on this. Do you think Santos Bonacci will win his case, and if so, why?
Well, again, when you start talking about winning and losing, you're talking about adversarial situations. Adversarial situations exist within the Admiralty jurisdiction. What we would hope, certainly through Solutions in Commerce, is that we stop being adversarial and start coming into harmony. Coming into harmony is the whole purpose behind the acceptance for value technology. And that is, we agree quickly with our adversary while we're in the way with them, as the master said. And so I don't know exactly what Santos is actually attempting there. There may be some point that he's trying to make, but I certainly know, having conversed with him and listened to some of his productions on the internet and so forth, that he understands acceptance for value perfectly. And so if he has gone into adversary or into an adversarial proceeding, I would suggest that there's some point, that he's trying to make from that position. I myself probably would not do that. But that, again, that's Santos, and only Santos knows what's in Santos's mind.
Right. Well,
the same thing for Dean.
Yes. Might as well conclude this by just giving my 2 cents in saying that the best way for banks to control a society is to loan people money that does not exist and charge interest on the loans, because the fact that they charge interest on the loans means debt and inflation is unavoidable, and a lot of the money is just numbers on, well, it's all numbers on a screen, but a lot of it is digital. And if you look at your paper money in America, you will notice there are no bills that have the date 2010 or above. Only 2009s and below are on the paper money. They are still making coins that are up to the present day, but paper money, it's not that way anymore, and they do want a global electronic currency. Of course, there are fundamental implications for freedom because you can't use cash as a backup plan, and we obviously don't want them to do that because that's a huge step towards enslavement. Well, that's about all I have to say, and I guess you might as well call it a day. This was a fascinating interview. I'll upload it to my YouTube channel, but by all means, upload it to your YouTube channel as well. We'll kill 2 birds with 1 stone there. And Winston, I might as well conclude this by telling you the same thing I tell all my guests. Even though you're a fascinating individual, and I'd love to have you on again. Problem is, I've made a resolution on this show to get as many different people on the show as possible before giving any one specific guest double dips, because that's the fairest way to make sure all the fascinating individuals on this planet get some glory on my show. So if you don't hear from me, that's only because I found some other people to have on my show. But still, it was a great interview. Loved having you on.
Well, thanks for having me. I'm just always pleased to have some input into the community of people and try to give as much good knowledge as I'm in possession of. So thank you very much.
You sure did give some good knowledge today. Thank you very much, Winston. Namaste. Take care.
Oh, namaste to you too.
Take care now. That was a great interview. Said it once, I'll say it again. And Winston, like I said, makes learning law fun. In your free time, study law by Winston, and you will like it. Well, that concludes this show. Next week, I am scheduled to have UFO whistleblower and pilot extraordinaire John Lear on my show. We will be talking UFOs. We will be talking extraterrestrials, and we'll even be talking about 9/11 because John Lear is a foremost researcher in 9/11 in regards to 9/11 related subjects that many truthers in the 9/11 truth community do not want to discuss, such as holographic planes. But we'll talk about that in the interview next week. So John Lear next week, next Wednesday, June 18th from 6 to 8 p.m. Eastern. I hope you all tune in for that. It should be a very formative and fascinating interview. I hope you can handle the truth about aliens, because some people can't handle the truth about aliens. Well, we'll try to make you handle the truth. John Lear and I. So John Lear next week. Namaste, everybody. Take care. Enjoy your experience throughout consciousness.